Good morning. My name is Sarisha Ganta, and I'm an attorney with the Pro Bono Partnership of Atlanta. And today we're excited to have Parker Stevens with us from Morris, Manning, and Martin to speak to us about COVID-19 leasing issues. Thank you, Parker, for being with us this morning. In this installment of the Pro Bono Partnership of Atlanta's webcast series, we'll be talking about leasing issues. But I wanted to first take a moment to tell you a little bit about the Pro Bono Partnership of Atlanta. Our mission is to provide free legal assistance to community-based nonprofits that serve low-income or disadvantaged individuals. We do this by matching eligible attorneys with the brightest corporations and law firms in Atlanta with our nonprofit clients to assist them with business law matters. Our clients are 501c3 nonprofits who are located in the greater Atlanta area and serve low-income or disadvantaged individuals. And these nonprofits are otherwise unable to afford legal services. If you're interested in learning more about our organization or to apply to become a client, please visit our website. Also on our website, you'll find a lot of great resources, including articles and past webcasts. This webcast will also be posted there in a few days. Please keep in mind that today's presentation is just general guidance. It is not specific legal advice for your organization. If you have any specific questions, please reach out to your attorney. And today's presentation is also copyrighted. And now I will pass the mic over to Parker to tell us about COVID-19 leasing issues. Thank you, Parker.
Thank you, Sarisha. I hope that you can hear me. Thank you for having me. It's good to be here, and thank you for everyone tuning in. I think this is an important and timely topic given the situation we find ourselves in. As we all know, there have been businesses that have been forced to close due to COVIDs. Businesses are losing revenue and having trouble paying rents. Space is being utilized less. Remote working is being utilized more. Businesses are being forced to utilize higher cleaning measures, more sanitization, and just in general, businesses force much unpredictability in the markets. And you see a lot of these issues being played out in the environment of leasing, and you see the impact of COVID on both landlords and tenants. So I wanted to talk about a few these related topics today, and a few things we'll look at, including if you have a commercial lease, what to look at if you're a tenant, or if you're a landlord. If you're a tenant, what potential relief you may have under your lease, or if you're a landlord, how strong your lease may be related to COVID issues. If the lease perhaps does not provide relief under the terms of the document, then what are some options that landlords and tenants have to possibly restructure their lease? And then if restructuring is not an issue, then if you're either a commercial or a residential landlord, what options do you have as you perhaps move towards eviction? I just want to note that we'll be focusing here, where applicable, on the Atlanta and Fulton County areas, and that's also noted that this presentation is geared towards nonprofits, but many of the concepts that we discuss in this presentation will apply to nonprofits and for-profits equally, but if there is a distinction, I will note that. So often I'm given or I'm asked by a tenant or landlords whether it's things have gone sour and they're unable to pay rent, or they're just being precautionary and they want to know what relief they have under their commercial lease. And the first question is always going to be, what does the lease say? And here are a few things that I will look at specifically to sort of do a temperature check. This is typically from the point of view of a tenant. wanting to know what options they have, possibly either not to pay rent, not to pay rent fully, or to perhaps shutter their business for a period of time if they're having trouble bringing in revenue. And one of the first provisions that I'll look for in a commercial lease is force majeure. And first I'll see if it's actually in the lease. Sometimes it's not. But if it is, it's a good place to start to see if a tenant will have any recourse under the lease. And force majeure is a French term meaning superior force. It's a legal concept under contract law that's been around for a long time. That's essentially will exempt one or both parties under the contracts from obligations under the lease in this circumstance due to unforeseeable circumstances beyond their control. And these typically involve what they call acts of gods, which are typically meant to be certain natural disasters, hurricanes, tornadoes, lightning storms, but can also include unforeseeable acts of people, including theft, vandalism, acts of war, terrorism. So what to look for in these provisions? Well, the first thing to look for is if the person who drafted this language was creative enough to include pandemic or epidemic language. And if so, that's a good place to start. I see this sometimes, not a lot, but it's a good example of how these provisions are really up to the creativity of the lawyer drafting them at the time. And I see all sorts of things being put in force majeure clauses. And if you have pandemic or epidemic language, that's a good place to start. But if you're a tenant and it says that certain obligations are excused during a pandemic, that's not the end of the analysis. There are several other questions you need to ask when reviewing a force majeure provision. For example, is performance excused if it becomes impossible or maybe a lower standard of impractical? If it's impossible, it's a harder argument to make. If there aren't government shutdowns in place, it might not be deemed impossible to perform, but it might be deemed impractical. So that would be something to look at. You'd also want to check to see if your force majeure provision requires notice. For example, some force majeure provisions will require at the beginning of the event within a certain amount of time, say 30 days. If the tenant has not given notice within that period of time, then the landlord will have an argument that the tenant, in fact, has waived any rights under that force majeure provision. Similarly, there are mitigation requirements sometimes within a certain amount of time of the force majeure events. There might be something that the tenant is obligated to do, whether it's cleaning or other preventative measures, that if not done within a certain amount of time, the landlord again may argue that you've waived your rights under a force majeure provision. And then finally, most force majeure provisions will not excuse the payment of rents, even if the provision applies and all the other boxes are checked. So this can provide some relief if you've checked all these boxes and the pandemic language is in there. But in most cases, the tenant will still be obligated to pay for rent. But again, each force majeure provision is different. And just as an example of that, and to just show how these are really based on the creativity of the drafter at the time, I like this provision that I found. It has some of the normal things that we talked about that you would find in a force majeure provision, sort of act of God, acts of war, public enemies. But I liked how this particular drafter included not only restraint of princes, but included pirates as well. So they may not have thought of pandemic, but they did get pirates in there. And 2020 is not over yet, so they may very well still be able to benefit from this provision. So a few other things to look for when you're scanning a commercial lease to see how strong it may be if you're a landlord, or what relief you may have as a tenant. Operating hours provisions. If a tenant is required to operate for a certain amount of days and a certain amount of hours. Without some sort of applicable force majeure provision, these are likely enforceable, and a landlord can, without either force majeure or some government shutdown, enforce these operating hours. And similarly, if you're a landlord and you have obligations under the lease to operate maybe common areas or other areas of the building under landlord's control, without force majeure or other provisions in the landlord's favor, they're obligated to maintain those areas as well. I've received a lot of questions, mostly from tenants, as to whether their landlord can force them to do enhanced COVID-related cleaning. Perhaps if there's a positive case in the building, can a landlord force a tenant to perform additional cleaning? And again, it's what does the lease say? I will typically look to see if the landlord is obligated to maintain the premises in good working order. They almost always are, and I'll check to see what additional language that may be in the lease that perhaps strengthens the landlord's position there. And other language may bolster the landlord's position, including if the tenant is obligated to take steps to ensure that the tenant's business does not interfere with the landlord's operation of the space or other tenants in the building, then the landlord has grounds to essentially make the tenant take some sort of extra cleaning measures to their premises. Okay, so what if we've looked at the lease and no force majeure, or maybe no helpful force majeure? What legal relief is possibly available in Georgia outside of the lease? And at this moment, the answer is that there are more questions than answers, namely because this is such a novel circumstance. There are questions to ask, such as, is COVID-19 an act of God? There is Georgia common law, without getting too deep into the legalese, but Georgia will forgive performance under a contract, including a lease, if there is an act of God's. But under Georgia law, this is construed pretty strictly, and it's typically limited to what we discussed before as natural disasters, hurricanes, things in that nature. And just as an example of the courts construing this narrowly is that in 2008, during the economic downturn, it was litigated as to whether the downturn itself was an act of God, and it was determined not to be. There are other legal doctrines that may apply, frustration of purpose, possibility. We won't get into the details of those here, but the point to take away is that these are all likely to be litigated in the future, but for now, there remains uncertainty as to whether, as a tenant, you're going to get relief from the courts under any of these legal doctrines. So we've looked at the lease. Perhaps there's no recourse there. Georgia courts not giving us a lot of help at the moment. So this is where I find myself with most of my clients currently, which is some sort of attempt to restructure the lease. I've heard this called also compassionate collection, which is a situation where a tenant is seeking relief from a landlord and trying to negotiate something that is workable to keep the landlord-tenant relationship in place. And a tenant can ask for relief in many different ways. What I see mostly is a tenant asking for a partial or total rent, which is essentially free rent for a certain period of time. A rent deferral, which is not free rent, it's just paid back. Either it's tacked on to the end of the term, or it's perhaps paid, amortized over the remaining term so that the base rent just goes up a little bit each month so that it's paid back over a certain amount of time. Or if this makes the most sense, some sort of negotiated early termination of the lease. And when considering lease restructuring, landlords perhaps should consider what they can gain in this sort of restructuring. It doesn't have to be one-sided. If I'm advising a landlord and a tenant is asking for a rent abatement or some sort of rent deferral, I will ask them if there's any way that's, it can be a mutually beneficial exchange if the landlords can perhaps improve their position while giving up short-term rent relief to the tenant. And just to quickly move through some of these things that a tenant could consider asking for, extensions of the term, if the lease perhaps contains a purchase option or a termination right that makes the property itself less marketable, a tenant may be willing to give that up in exchange for rent relief. If a tenant is unable to pay rents, they may be able to still enhance their letter of credit or security deposit. So that's something that a landlord may want to ask for. You may want to either add or increase percentage rents, which is basically just a percentage of the revenue that tenant makes past a certain breakpoint. If this concept is already in the lease, you may want to increase that number as it protects both the tenant and the landlord, because it won't kick in until business is booming again, but it will help the landlord recoup any free rents that it gives away during that time. Hopefully, you could consider adding guarantors or increasing the guarantee in a lease, or reallocation of any tenant improvement allowance to some other perhaps different projects in the building than what was originally planned. So those are just all things to consider when trying to make any restructuring mutually beneficial. And these are some practical considerations for landlords when, if you're considering entering into a restructuring. The main takeaway here is to get it in writing. Beware the handshake agreement. This is very important, not only because it memorializes the agreement, but without having it in writing, you risk waiving certain rights that you may have had under the lease, even if it's written in the lease itself. So any restructuring should be written, the exact things that are being agreed to, for how long, and explicitly noting that any other obligations of the lease are not waived unless set forth in the amendments. And I've heard anecdotally that some landlord and tenants are doing these handshake agreements, and again, I would advise against this. Often, if you're a landlord and you have a lender, you're going to need the lender's consent to any lease amendments. If you're in a sublease, then the master landlord is likely, consent is likely required from the master landlords. If there's a guarantee, you want to make sure that you go by the provisions of the guarantee for notice or consent, or otherwise you risk discharging the guarantee itself. So these are all reasons why you want to get any modification in writing.
Hey, Parker, we had a couple questions and I wanted to ask you them.
Sure.
This seemed like it might be a good time. One of them was, you might see it's a long question in the chat from David, but it's essentially, can a written document still allow for flexibility? If the landlord's trying to be flexible, but still have something in writing. Do you have any thoughts for that?
Absolutely. I think in these situations, creativity is key. I think flexibility is good, and that can be done in several different ways. And I think you can make, whether it's a benchmark or a flexible timing schedule of when things are being paid back. You can have deferral kick in after a certain amount of time, or be creative with the way that rent is paid back. Like I said, whether it makes sense to put it at the end of the term or to amortize it over the term itself. I do think there are lots of different ways, and I've seen it done lots of different ways. It's really just the position of the tenant and the position of the landlords. And just as a general takeaway, I'll note this later, but communication is key. Having an open dialogue, finding out what works best for the landlord and the tenant, can keep the lease alive, in my experience, in most cases.
And as you're going to be talking about future considerations, we have a question here that might be fitting. Do you think a pre-negotiation agreement is required?
I've seen those, and I have not. I don't come down one way or the other. I think it's really situational. I like them because it helps the parties be more open, without giving away too much. Again, this is sort of goes back to the, communication is key, but if you want to really protect yourself before going into these negotiations, then I do think that they're perhaps a good idea. Although in my experience, they have not been, I would consider necessary, but I think that might become more of the new normal as landlords become more open to these negotiations. I think this may help them feel more comfortable. Sure. So, yeah, that's a good lead into, these are future considerations, AKA things that I think are going to be negotiated, pretty heavily for leases that have not been inked up at this point. Like we talked about, pandemic and epidemic language comes up in almost every lease that I negotiate now, when before force majeure provisions were rarely looked at very closely. So this, again, is a very situational sort of thing. I think you'll particularly want to try to work these in if there is construction involved, to make sure that there are protections that, whether you're the landlord or the tenant doing the work, if you finish the work and try to deliver, you're going to want to make sure that you can deliver that work regardless of any pandemic or epidemic force majeure language. But on the other side, you want to perhaps work in some allocation of that risk to the other side if, for example, you're not able to actually accept your space. So there's a lot of nuance there, but it's definitely being negotiated heavily. In addition to insurance provisions, things like the effectiveness of business interruption insurance is being litigated currently. So as that pans out, I think that's, as tenants, if you have insurance in place that protects you from certain loss of rents, that you may try to negotiate a rent abatement during any time when that insurance covers that, and assuming your insurance does cover that, to give you sort of immediate relief while you pursue a claim under that insurance. Also, service charges, now that more enhanced cleaning is being required, if you're a tenant, you're probably going to want to try to get a cap on that, when you get into having to close buildings and do massive cleanings. And on the flip side, if you're a landlord, you want to keep this language as broad as possible so that you can recoup or be able to charge for all of these cleaning costs as just good estate management. So now we've moved from perhaps a restructuring did not work out. What are a commercial landlord's options for eviction? And this is essentially the same analysis that it would be outside of currently at least outside of a COVID-19 context. You're going to look at the lease to see what the notice and default sections are. You're going to follow whatever your local eviction proceedings are, because there are no current moratoriums on commercial evictions in Fulton County at this moment, which is not the same for the residential sphere. As many of you know, as of September 4th, 2020, the CDC put enforce the eviction moratorium, which is effective until the end of the year. And it's important to note here that this moratorium is not for all residential evictions. The specific resident is going to have to meet certain criteria, which summarized briefly here is that they must have lost substantial income during the pandemic, expect to make no more than $99,000 in 2020, or qualify to receive a stimulus check in 2020. The resident must be making their best efforts to make partial payments of rents, and should be making partial payments of rents to the extent they're able. And essentially that the eviction would force them into homelessness. So, and another major takeaway here is that despite the moratorium, all rents are still due. So that's an issue we'll talk about a little bit later, but this does not forgive rents. It simply defers it until the moratorium is lifted, which is as of now, January 1. And a few practical considerations related to the moratorium. Again, we're specific to Fulton County here. Perhaps this first part is not specific to Fulton, but it's worth noting that a tenant is not required to file a certification with the court stating that it qualifies for the things that we noted in the previous slides. However, it is required to provide that certification to the landlord. So if you know somebody who is trying to take advantage of this moratorium, the first piece of advice is to get this certification written in the hands of the landlord, and you can find the certification on the CDC's website. If you're a landlord proceeding towards eviction, though, you will have to provide the court with an affidavit stating whether or not you received a certification from the tenants before you proceed with the eviction. It's to note in Fulton County, there are no other COVID-related restrictions. So if the tenant does not qualify under the CDC moratorium, please note that eviction proceedings can be brought against that residential tenants, and they are occurring now, and they're occurring via Zoom. So just note that in Fulton County, evictions are proceeding, and this is different in every Georgia jurisdiction. So some counties have halted residential evictions altogether while they figure out how to proceed with the moratorium. I believe Cobb County has done this. I'm not sure this changes frequently. So the takeaway here is that it's very important to check with your local jurisdiction, even Fulton County, before proceeding with an eviction of a residential tenant. I think I see there's a question if there's anything specific for DeKalb County, and that will be something that I'd be happy to follow up with, but having focused on Fulton, I can only speak to that right now. But as noted, there are, from county to county, different takes on the moratorium. But I will say that the moratorium is considered to be only a floor. So if a county has a perhaps more restrictive or more cumbersome moratorium, that will apply, and it won't. And the CDC moratorium does not override; it only serves as a floor. And so, just a few sort of things that I get asked a lot about, and things that I think about a lot. I think we can all agree that it's good for residential tenants to be given some relief, but we all have to wonder if this is a one-sided remedy and what the effect of that may be. If we're assuming that it's landlords that are the parties that are better able to assume the risk, then what happens to the smaller landlords? Because as we know, not all commercial landlords, particularly nonprofit landlords, are large firms with deep pockets, and most not only have loan payments, but have utility charges and other overheads. So, we have to ask, is there a flood building up under the dam of evictions come January 1. And, I think this is something that we should all be thinking about, whether it's, a more equitable division of losses, or whether we should expect or hope for other governmental financial supports in the future. But these are just some things to think about as we move towards the end of the year. And this is just sort of a side question, which is, so what if your landlord goes out of business? This is more in the commercial sphere, I would think, but the main point that I want to make is that if your landlord is either in bankruptcy or is under some sort of foreclosure, the answer is almost always going to be that your rent is still due to some party. So don't assume because perhaps they've gone out of business that you don't have to pay rent. It can be confusing sometimes which party is owed the rent, and if you're getting requests from multiple parties as to who to pay rent to, I would suggest speaking with an attorney and also trying to set up an escrow account so that the money is held until you can determine which is the right party to pay. We don't have enough time here, but depending on whether your landlord is in bankruptcy, the type of bankruptcy matters, and also if it's a foreclosure, then the party that you will be paying rent to may be different, and those proceedings will play out in different ways. But that's just something that I wanted to note. And also, well, perhaps not directly related to COVID, domestic abuse, as many of us know, has risen worldwide due to the COVID-19 epidemic. And I just wanted to note that Georgia does have laws on the books that would allow a residential tenant to terminate his or her lease before it expires if they're the victim of family violence and have a family violence protection order. And again, while this is not the main theme of this presentation, I wanted to note it, and I will be happy to provide more information on the side if anyone is interested on learning more about these housing laws. So what are the takeaways? As we noted in the beginning, if you're a commercial tenant or a commercial landlord's wanting to know either what potential relief you have under the lease or how strong / COVID protected your lease is, the first question is always, what does the lease say? Take a look at the force majeure provisions and some of the other things that we talked about. Go through it with your attorney and see where you stand with a lease that was signed before the pandemic hit. If no relief is available under the lease, remember that there are several ways that you can restructure a lease that can be mutually beneficial to a landlord and a tenant. As we talked about earlier, you can really get creative with these, get down to the details of the lease, find something that may be beneficial to the landlords if you are the landlord, and most of the time a tenant is willing to give up some of these inducements for the opportunity to stay in business and weather the storm. And always communication is key. I think pre-negotiation agreements are something to look more into. I think that they can be beneficial in keeping communication open. Talk to your attorney, before perhaps you engage your landlords, but typically having an open dialogue versus springing something on your landlords within a few days of making a decision will have a better result. If you're a landlord moving to evict a tenant, remember to take special caution, as the CDC moratorium is currently in place and is being implemented differently in every county. And finally, as just a bit of an editorial, as we know, these government intervention measures are not going to last forever and are currently only lasting until the end of the year, with no promise of any further measures. So we should all remember that the new normal is being defined not necessarily by outside forces, but by landlords and tenants working together, hopefully keeping leases in place, hopefully finding mutually beneficial solutions. And so that I think doing that will foster the recovery of both the residential and commercial real estate markets. So having said that, if there are any other questions, I'll be happy to answer them.
Parker, I wanted to address a couple questions that came to us through registration. One of them is more of a tax question, but I'm happy to address it because I think it is important to the topic. And the question is, if a nonprofit subleases part of its space, does it have to pay any taxes for that? And the answer is maybe. It depends on, it might be considered unrelated business taxable income. It depends on if it's debt financed, and it also depends on who you're subleasing to. If it's your sublessee is an organization that follows a similar mission or furthers a nonprofit's mission, then you're less likely to have to pay tax on that income. But that is a question that you should reach out to your PBPA attorney to get further guidance on. Another question we had, Parker, that I think it's not so much legal advice, it's probably legal/business advice, is do you have any thoughts about what to do about leases in the future, considering that there is anticipated to be an excess of space to be rented? Do you have any thoughts on that in terms of adding flexibility within a lease to get out of space?
Yeah, I mean, I think that's I definitely think that's a consideration more and more, and I'm seeing that play out. It's sort of an inverse of what I saw before the pandemic, which is that, you know, expansion options were something that tenants would try to bargain for. Now it's sort of a little bit of the reverse. I see, you know, retraction options. So if I don't, if it turns out that after a year I don't need this much space, then I, as a tenant negotiating this lease on the forefront, will try to bargain into the lease some sort of retraction option so that I can exercise that option and reduce my space if I determine it necessary. And I think you're going to see a good bit more of that in the future.
And David, I see your question. That would be something that you should reach out to your PBPA attorney about, and we can talk about options there. And one other question that is here is, do you have any recommendations on how to pursue the federal eviction moratorium? Would that be with the local magistrate court?
If your landlord is looking to proceed with an eviction, yes, it's with the magistrate courts, and that's the two sort of paperwork pieces there are, first of all, this is, if you're a tenant, this is why, if you think you qualify for the moratorium, you should provide your landlord with that certification that says that I think I qualify. If your tenant has not done that, then under the moratorium, you can still proceed, and it is in magistrate court, and it will be done via Zoom, and you'll be asked to sign an affidavit that says that you have not received that certification from the tenant. But yes, that is the basic sort of procedural basis on which to pursue an eviction.
Okay, great. I believe that's all the questions that we have, Parker. Thank you so much for sharing your expertise with us this morning. We really appreciate it.
Thank you so much for having me.
And thank you to our audience for tuning in today. Take care, y'all.
Thanks, everyone. All right, bye.